appeal in the matter of AK and the Home Department.
Yes, Mr. Malik.
My Lord, I appear for the appellant this morning, was present in court with his partner. My learned friend, Mr. Tabri, appears for the Secretary of State.
Yes. Now, before we get underway, we are all completely puzzled as to why the appellant has been anonymised.
Yeah.
So thoroughly anonymised that every trace of his surname has been removed from the documents, and yet this is not a risk on return case, and we simply can't see why he should remain anonymous.
My Lord, that is pursuant to the order of Lord Justice Arnold,
Yes.
Granting permission to appeal, and pursuant to the orders made below.
Yes.
There is, of course, a reference to the appellant being a victim of sexual abuse as a child. Probably that was the reason why the case was anonymized. I don't know, but my Lord is absolutely right that this isn't a protection appeal. There are no safety issues as such.
Well, unless you'd like to make submissions to the contrary, we would like to know his name, and we would propose, when we give judgment, to name him.
Lord, may I respectfully? I mean, of course, there is no application from the other side before you to discharge the anonymity order. May I respectfully propose that you hear submissions, and I'll reflect on that in due course. My instructing solicitor is sitting behind me. If there is any particular reason as to why anonymity is justified, then I will flag that.
Well, we'll rise for a few minutes so you can discuss it with your solicitor and your client. And Mr. Tabori, I imagine you're neutral on this.
Yes, we are.
issue. Yes.
I'm very grateful. I just need 2 minutes.
Yes,
very
of course.
grateful. I thought they would ask that question.
Yes. So, well, Justice Arnold thought they were reflecting an order made below. Is that right?
That is right.
Who actually made it below?
It was anonymized in the previous appeal proceedings as well.
this is a mistake.
It's basically a mistake.
Good spot.
It's carried.
What's it? I do.
Sorry, just 1 minute, please. Ready? Yeah, thank you.
Full rise.
Yes, Mr. Malik.
Very, very grateful for the opportunity. Lords, I make no application to preserve the anonymity order. I'm happy to name the appellant in open court.
Yes.
And I'm happy to provide you a bundle that is not anonymized in due course if you wish.
Well, don't worry. If you just give us the name.
His first name is Alick, A-L-I-C-K.
Yes.
And his surname is Kapik Anya, K-A-P-I-K-A-N-Y-A.
K-A-P-I-K-A-N-Y-A. Yes. Right. Thank you very much. There's no need to unredact any documents. That answers that question. Right. On with your substantive submission.
Yes. So, my lords, this I must confess at the outset is a troubling case. It is troubling both from the public interest point of view and the individual point of view. The appellant has committed serious financial crimes. Those crimes include attempted fraud, theft, false representations for gain, and conspiracy to fraud. He has received various sentences for those offences, and for the index offence of conspiracy to fraud, he was sentenced to 6 years in custody. So, my lords, from the public interest point of view, he is a perfect candidate for deportation. No part of my submissions this morning will seek to underplay the seriousness of his offending or the compelling public interest in his deportation. But from the individual point of view, my lords, he is someone who has lived in this country for 42 years. He came here in 1983 as a child to be adopted by a family. That did not happen, and instead of becoming part of a family unit, he was assimilated in a religious cult. And my lords may have seen from the papers that he became a victim of gruesome sexual abuse as a child. His life as a child and young adult has been truly remarkable. The first year tribunal, my lords, held that the circumstances of his case were very compelling, so compelling that they outweigh the public interest in his deportation. The upper tribunal on the Secretary of State's appeal set aside the first year tribunal's decision and substituted a fresh decision that there are no such very compelling circumstances. So, my lords, the primary question before this court is whether the first year tribunal had erred on a point of law in allowing the appellant's appeal. And I shall seek to persuade my lords that the first year tribunal, contrary to the conclusion reached by the upper tribunal, made no error of law. Therefore, I shall submit it was not open to the upper tribunal to set aside that decision and substitute a fresh decision. And my lords, that is my ground one. My lords, my ground two is an alternative ground which my lords will need to consider if ground one fails. It concerns the upper tribunal's remade decision. I shall seek to persuade you, my lords, that the upper tribunal, when remaking the decision, erred in its approach and gave inadequate reasons. Now, this is a very familiar territory for the court so far as the law is concerned. So, subject to any observations, what I propose to do this morning is to make some brief submissions on the law first, focusing first on the law as to the upper tribunal's jurisdiction to set aside the first year tribunal's decision, and then the statutory regime concerning deportation of foreign criminals. I will then, my lords, take you to the first year tribunal's decision and the upper tribunal's error of law decision and make submissions on ground one. And then, subject to any observations, my lord, I will address you on ground two and the upper tribunal's remade decision. So law first, and I'll start with the upper tribunal's jurisdiction. Lords, the upper tribunal's jurisdiction to hear an appeal from the first year tribunal is governed by sections 11 and 12 of the Tribunal's Courts and Enforcement Act 2007. Now, those provisions and their effect is helpfully summarized in a recent judgment of this court. So may I take you to that judgment? That is behind tab 12 of the authorities bundle. the judgment of this court in Ola.
I was just looking to see whether it was a case you weren't in, but
Yes, for my sins, yes. So Ola is a case where the first year tribunal allowed the appellant's appeal. The upper tribunal set aside the first year tribunal's decision as being wrong in law, and the matter then reached this court. May I ask you respectfully to go to page 287 of the bundle, where you will see paragraphs 18 and 19 of that judgment. This is the judgment of Lord Justice Green. At paragraph 18, Lord Justice Green quotes section 11(1) of the 2007 Act, and he makes the point that the upper tribunal can only exercise its jurisdiction in respect of points of law. A right of appeal from the first year tribunal to the upper tribunal is available only on a point of law, and that point of law must arise from the decision. So in other words, there is no appeal on facts. The upper tribunal cannot interfere with the first year tribunal's decision on the basis that the decision is wrong, unless the error in question is an error of law. Now that is a matter that goes to the jurisdiction of the upper tribunal, as it is clear from paragraph 19. Now you will see that at paragraph 19, Lord Justice Green quoted section 12. In deciding, this is the question for the upper tribunal in deciding an appeal is whether the first year tribunal's decision involved making an error on a point of law, and the jurisdiction to set aside the decision only arises if the upper tribunal answers that question in the affirmative.
Yes.
So in other words, there's no jurisdiction to remake the decision absent an error of law. And that is the reason why, when introducing the case, I said that the basic question for my lords is whether there is an error of law in the first year tribunal's decision.
You've actually cited Lord Justice Green's paragraph 26 as your skeleton argument, paragraph 20, isn't it?
Well, I'll say this with the greatest of respect. It's actually the other way around.
Oh, I see. Well,
So-
he may have taken it from
Yes.
you in your submissions in that case. But
Yes,
anyway,
so
it's
my-
the same series of points.
Precisely. So
Yes.
those were the points that I made in my skeleton argument. In that case, the points were not controversial, and Lord Justice Green felt it appropriate simply to adopt and quote those points. I do ask you, my lords, to look at those points now and apply those principles in testing my submissions.
Yes.
The first year tribunal, as the Lord knows, is a specialist fact-finding tribunal. The upper tribunal should not rush to find an error of law simply because they might have come to a different conclusion, and this is important, or expressed themselves differently. Where a relevant point is not mentioned by the first year tribunal, the upper tribunal should not assume automatically that it hasn't been taken into account.
There is one respect in which your paragraph 20 differs from Lord Justice Green's paragraph 26. And if you look at subparagraph 6, in Lord Justice Green's text, it says it is of the nature of assessment
Yes.
that different tribunals may reach different conclusions.
Yes.
That morphs into, in your submissions, it is of the nature of proportionality assessment.
Yeah.
But I think I'm pretty clear Mr. Tabori is going to say this is not a case about proportionality assessment.
Well, the reason why the word proportionality is missing from the summary in Lord Justice Green's judgment is because that case was not about proportionality. That case was about a finding that the appellant was dishonest. But the word...
Well, the first-tier tribunal had found that he wasn't.
Yes.
And you were able to persuade the Court of Appeal quite rightly, if I may say so, that the upper tribunal had no business to interfere.
Now, my Lord, you have, of course, seen, just to answer your point directly, you have seen the reference to the judgment of the Supreme Court in MM.
Yes.
In my paragraph 20 and in Lord Justice Green's paragraph 26. Well, you don't have that judgment, but the word proportionality actually appears in that judgment. And this case, as I shall seek to demonstrate, is about proportionality, nothing else. But the fundamental point, my Lord, that arises from the paragraph that I'm showing you is that different tribunals do make different decisions, and the fact that one judge makes a decision that appears to be lenient or generous does not mean that it is wrong in law. No obligation on the judges to cite expressly relevant authorities. They are to be taken to be aware of the law. And these are the principles that I respectfully invite you to deploy. Now, with that in mind, may I respectfully take you to the statutory provisions concerning deportation of foreign criminals, tab 1 of the authorities bundle. My Lords, have looked at section 117C on various occasions. Page 5 of the authorities bundle, where you have that provision. You'll see that there are two exceptions, private law exception in subsection 4 and family law exception in subsection 5. So far as the private law exception is concerned, you will see that limb C says there would be very significant obstacles to C's integration into the country where C is proposed to be deported. Just a very, very quick point about that provision. It's not directly relevant to this case, but the submission is that the test requires a broad evaluative judgment, and that in turn includes consideration of whether an applicant would be able to build within a reasonable time a variety of human relationships to give substance to his private or family life.
What was the FTT judge's finding on that?
There is no finding by the first-year tribunal as to that provision, because that provision does not apply to this case. I'm making submissions very briefly as to those provisions in the light of what Valerian Friend has said in his skeleton argument. But the two exceptions do not apply here, simply because the appellant has been sentenced to over 4 years. So the statute, my Lord, creates a distinction between medium offenders and serious offenders. A medium offender is someone who is sentenced to less than 4 years. That offender can rely on sections 4 or 5. Subsections 4 and subsections 5. But those subsections are not available as such to a serious offender. So there is no finding as to that exception by the first-year tribunal. There is a finding by the upper tribunal in the remade decision and for that reason, I just felt it appropriate just to address it very briefly at this stage. Subsection 5, the family law, the family life exception, stipulates the unduly harsh test. It is for the fact-finding tribunal to make an informed assessment of the effect of deportation on a child or a partner, and to make an evaluative judgment of the facts and circumstances of the case. That is what that test entails. But what the decision makers must not do is that they must not use a notional comparator in making that assessment. What that means, my lords, is that the test does not require a comparison to be made between the degree of harshness which would necessarily be involved for any child faced with a deportation of a parent, and the facts of the case before the fact-finding tribunal to decide whether there is a degree of harshness which goes beyond that, beyond what would necessarily be involved for any child. This is what the Supreme Court had said in H. Iraq, and I'll take you to that authority.
Yes, please.
Well, this case, as I said, is not about exception 1, it's not about exception 2. This case is about subsection 6. In the case of a foreign criminal who has been sentenced to a period of imprisonment of at least 4 years, this case, the public interest requires deportation unless there are very compelling circumstances over and above those described in exceptions 1 and 2. And what I make three very short points as to this subsection. First, over and above does not mean in addition to. It is not necessary for the decision makers in a case of a serious offender to make any finding as to the 2 exceptions. A serious offender may rely upon matters falling within the 2 exceptions or features falling outside the circumstances described in those exceptions, or both. Second,
has that been held by an appellate court?
Yes, and
I'll give us the reference without taking it.
So I will, subject to any opposition, I'll make my 3 propositions, and I'll then take you to 2 authorities in support of those propositions. Second, and this, in my respective submission, addresses the point that my Lord Lordis has been made when I opened the case, that this case wasn't about proportionality. The second proposition is that what subsection 6 requires as a matter of law is a proportionality assessment. The decision maker must conduct a full proportionality assessment, weighing the interference with the Article 8 rights of the applicant against the public interest in his deportation. In conducting that proportionality assessment, the decision maker must proceed on the basis that the public interest requires deportation unless there are very compelling circumstances. So very compelling circumstances assessment, in short, is proportionality assessment. And the third proposition, my lords, is that in making that proportionality assessment, the best interests of a child are a primary consideration. They carry great weight. Natural love between parents and children and desirability of children being with both parents is not enough. There must be something more than that. In my respectful submission, there are only two authorities that this court needs to look at to justly determine this appeal. The first is the judgment of the Supreme Court in Hache, Iraq, which reconciles all earlier authorities on the subject. And second is the judgment of this court in Yalchin, where Hache, Iraq was considered and applied. So I'll take you to the two authorities in turn.
Could I just unpick something that you said a moment ago?
Yes.
Which is, you said that the best interests of the child are primary consideration, which is a statutory principle. You then said they carry very great weight.
Yes.
I'm not sure that that is a statutory principle. I mean, clearly, where a child is involved, there will be, in some cases, huge amount of weight will attach to the interests of the child. In other cases, maybe less so because of circumstances. So I don't think primary consideration and carrying a very great weight are synonyms for each other in all cases.
I would not resist against that.
It's not a point against you. It was simply,
Yeah.
as we're dealing with legal analysis at the moment.
Yes.
Thank you.
It's just that I'll show you the case law. Courts have said that the welfare of the child carries great weight, but that, of course, does not mean that great weight is to be given.
I was only trying
every single
to
case,
rather punctiliously trying to unpick the difference between considering something and giving weight to it. One gives weight to something one way or the other once one's considered it.
Yes. No issue with that.
And primarily considered it at the head of the queue, as it were.
Yes.
Thank you.
So two authorities then. The first is Hache, Iraq, tab 10 of the authorities bundle. And again, what I will do is to show you all paragraphs that are relevant to both grounds in order to save time, and we'll of course show you the paragraphs that support my propositions. So this is the judgment where the Supreme Court looks at section 117C. There was a conflict of authority at the level of this court. Some constitutions had said that the unduly harsh assessment requires comparison with a notional comparator and taking into account seriousness of a person's offending. Other constitutions had said that that was not permissible, and the Supreme Court then picked 3 cases to resolve all relevant issues. 2 appellants were medium offenders, Hache and RA. A was a serious offender, was sentenced just like this appellant to more than 4 years. So if you go to page 226, my lord, will see paragraph 5. The very compelling circumstances test, and that is why I say this case is nothing but about proportionality. The very compelling circumstances test requires a full proportionality assessment to be carried out, weighing the interference with the Article 8 rights against the public interest. subsection 6 requires proportionality assessment. Very compelling circumstances mean proportionality assessment. May I then, my lords, take you to page 231. Just above paragraph 23, my lords, will see a heading, the case of the appellant Secretary of State. Now this is important on the facts of this case. You'll see that the Secretary of State relied on the judgment of Lord Cornwallis in a case called KO Nigeria, and relied in particular at paragraph 23. The Secretary of State submitted that what Lord Cornwallis was saying in KO Nigeria was that unduly harsh test requires a comparison with a notional comparator, requires a comparison to be made with a degree of harshness which would necessarily be involved for any child faced with the deportation of a parent, and that undue harshness means degree of harshness that goes beyond that. So the baseline would be any child, and then an assessment as to whether harshness exceeds that baseline case. It is that notional comparator that provides the baseline. The Secretary of State said that was the effect of KO Nigeria. The Supreme Court disagreed and rejected that argument categorically. If you look at paragraph 30 of the judgment, page 233, Lord Hamblen says, I reject these submissions on a number of grounds. And you then have detailed reasons as to why deploying a notional comparator to make an assessment would be an error of law. There is perhaps no need for the court to look at those reasons in detail, because the Supreme Court has said that there is no notional comparator. But what the assessment of unduly harsh requires is at paragraph 41. Sorry, before I ask you to look at paragraph 41, may I ask you to look at paragraph 40? Because I will make that a submission as to that when I show you the decisions. Lord Hamblen said that the Secretary of State's understanding of Lord Cornwallis' judgment was not correct. He was not contemplating a notional comparator test, although with respect to one reading of his judgment indicated that he was. So the test, what the test requires, this is paragraph 41, is not simply uncomfortable or inconvenient or undesirable or difficult, something more. So it's an elevated standard that is required. But a rather fundamental point is at paragraph 44, which is at page 236, that ultimately it is for the fact finder, for the first year tribunal, to make an informed assessment of the effect of deportation on the qualifying child or partner, and to make an evaluative judgment as to whether the test is met. So ultimately it comes down to evaluative judgment, an evaluative judgment without a notional comparator.
Is paragraph 39 relevant?
Yes, so this is one of the reasons that Lord Hamblen gives for rejecting the submission. And all 5 reasons are relevant. Of course, I accept that paragraph 39 is. There is perhaps, as I said, no need for this court to analyze those reasons in detail in this case, because of course my lords will apply the conclusion that is reached by the Supreme Court.
Just dropping this decision into the chronology of our proceedings, it predates
Yes.
both of the tribunal decisions, which came in January 2023 and
Yes.
October 2023, February 2024. So it didn't fall into the middle of the proceedings of this case. It was established by then.
Yes. Yes. So just for you know, just two short points that arise from this analysis. First, there is no notional competitor. Second, an evaluative judgment is required, an evaluative judgment by the fact finder. Now, you'll then see a heading, the very compelling circumstances test, above paragraph 46. And this is where Lord Hamblen discusses the effect of that provision. If you look at paragraph 47, you'll see that Lord Hamblen endorses what Lord Justice Hill had said. And you'll see A and B at paragraph 47. A is the medium offender. A medium offender can succeed by establishing that he falls under the two exceptions. But it is B that is relevant here. And this again reinforces the submissions that I made and reinforces what Lord Hamblen said at paragraph 5. In cases where the two exceptions do not apply, this case, because this is a case about serious offender, the very compelling circumstances test requires full proportionality assessment. He's making the point again that he made at paragraph 5.
Yes.
Full proportionality assessment.
Yes, of course that's right. When I said it's not simply a proportionality assessment, what I was saying rather clumsily was the question is not just would deportation be disproportionate. The proportionality assessment involves balancing the criteria set out in 117C, the public interest in deportation set against the appellant's Article 8 rights and the Article 8 rights of a qualifying child or qualifying partner. It's not simply would deportation be disproportionate, it's would deportation be, it seems to me, have an unduly harsh effect, and are there very compelling circumstances over and above that? So it's a particular kind of proportionality assessment.
Lord, I shall, over the next 30 minutes or so, I shall seek to persuade you that isn't, in my respective submission, an accurate analysis of this judgment. I'll show you. I'll show you the relevant paragraphs. As I said, over and above does not mean in addition to. So it's not the case that a serious offender must demonstrate that the unduly harsh test is met, and in addition to that, there are very compelling circumstances. Over and above does not mean in addition to. But secondly, this is a proportionality. Yes.
Just so I understood this, you're saying that for a person in your client's position, they don't have to go through the hoops of proving 4 and 5,
Yes.
as well as proving 6.
No, they have to, of course, prove 6 for sure.
Yes, they have to prove 6.
Yes,
But
they don't.
I'm just trying to see what the effect of your your submission that it's not in addition to.
Well, yes. So that, in short, means that the fact-finding tribunal, instead of going through exceptions 1 and 2, goes straight to 6.
That's what
Doesn't have to consider the question through the prism of the factors, in this case in
Yes.
5,
Yes.
for unduly harsh.
Yes. There's no legal requirements.
It's not, it doesn't have to be unduly harsh and very compelling circumstances.
Yes.
If the unduly harsh test doesn't apply because the case doesn't fall within exception 2,
Yes.
you go straight to very compelling circumstances.
That is the submission. Yes.
That's a submission. Is there a clear statement
Absolutely.
of authority
Absolutely.
you're going to take us to now?
There is, yes. So I'll show you all relevant paragraphs of H. Iraq, and then this
Yes,
post judgment in Yelchin.
Okay.
And by the end of that, it will, in my respective submission,
All our anxieties will be
absolutely
laid to
clear.
rest.
Yeah.
On this submission.
Yes. So when my Lord Lords has been observed that, well, what is required is unduly harsh and very compelling circumstances, I shall submit that isn't accurate, and I will make that point good.
All right.
Second, there is extensive discussion in this judgment and in the next judgment as to whether there is a difference between very compelling circumstances and proportionality. The message is absolutely clear. It is the same. So the task of the decision maker is, when making an assessment under subsection 6, is to weigh in balance the private interests of the potential deportee, spouse and child against the public interest in deportation.
Well, my eyes are lighted on an observation of Lord Reed, cited by Lord Hamlin, paragraph 47,
Yes.
in which he says,
Yep.
49.
what did I say?
Yeah.
47, 49.
Great weight. Yes.
Applying a portion, it can be outweighed, applying a portion of penalties by very compelling circumstances.
Yeah.
So you've got Lord Reed on your side.
Yes. Yes.
As well as Lord
And Lord Hamlin and Lord Sandhill in Yelchin. So I've shown you 47, paragraph 47B, subsection 6 requires full proportionality assessment. And then B also tells you what that assessment entails. Weighing interference with Article 8 rights against the public interest in the deportation. It's the middle of B. That's it. And then I'm grateful.
So that's Lord Justice Underhill in the court below.
Yes, which was endorsed by Lord Hamlin. He says, well, the difference in approach was conveniently summarized by Lord Sandhill in the judgment. And then, of course, you have paragraph 49 that you've just referred to. So this is 46 and 47. If you then go to, I mean, if there is any doubt as to the correctness of the submission that I'm making, may I ask you to look at paragraph 51? Just
Well, you bypassed Lord Justice Jackson in NA.
Yes, the reason, yes, my Lord, well, those particular paragraphs, yes.
I mean, the reason I mention that is because it seems it's headed how exceptions 1 and 2 relate to the very compelling circumstances was addressed by Lord Justice
Now,
Jackson.
the reason why I've skipped them is because those two particular paragraphs were subject of discussion by the judgment of this court in Yelchin, which followed H.A.
All right.
I'll take you to that, but Lord, this is what is said. And Lord Sandhill in Yelchin explains what Lord Justice Jackson actually meant in those paragraphs. What I respectfully invite my lords to look at is paragraph 51. When considering whether there are very compelling circumstances, all relevant circumstances will be considered and weighed against the very strong public interest. And you then have an absolutely clear endorsement of the fact that the Strasbourg jurisprudence on proportionality is what that subsection 6 requires. You have references to well-known authorities, Unani, Uni, and Bultif. And then you have list of factors that are relevant. And it is that list that I especially invite you to take note of. The first bullet point is nature and seriousness of the offence committed by the applicant. I said at the outset that I'm not going to say anything that underplays seriousness of the offending by this appellant. But he has committed serious financial crimes. And this is one of the points that the first judge made, that although these are serious crimes, there are crimes that are far more serious than that. Crimes involving serious violence, terrorism, sexual offences. The more serious the offence, the stronger would be the public interest in deportation. So you have to look at the nature and seriousness of the offending. The length of the applicant's stay in the UK or in the country to which he is to be expelled, 42 years in this case. Time elapsed since the offence was committed and the applicant's conduct during that period, that goes to rehabilitation. It's relevant because the offence here was committed in the index offence was committed in 2014. If there is evidence of rehabilitation, if there is low risk of reoffending, then that goes into proportionality assessment. The applicant's family situation, partners, etc. The seriousness of difficulties which the spouse or child is likely to encounter if the applicant is to be expelled. Now, there is no unduly harsh test there. So nature and seriousness of difficulties. So when conducting a sort of proportionality balance, there's no requirement in law for there to be a finding that the consequences of deportation would be unduly harsh. The focus must be on all relevant matters, including the difficulties that a spouse or child would face, and consideration of that together with all other relevant matters, and then balancing that against the public interest. So no unduly harsh test in the assessment under subsection 6.
Well, are you saying that that's something laid down by HA Iraq?
Well, yes. This is, you'll see that at paragraph 51, Lord Hamblin said that, well, as explained by Lord Reid, relevant factors will include those identified by the European Court of Human Rights, and these are the relevant factors. But that, just to make it absolutely clear, I'm not suggesting that if there are serious difficulties that the spouse or the child would face if the applicant is deported, the applicant succeeds. That isn't my submission. The submission is that is one of various matters that the fact finder will take into account. It may be that there are some difficulties arising from deportation, or only some difficulties, not unduly harsh difficulties, but some difficulties. But then you have a case where a person has lived in the country for 14 odd years. The offence that person has committed is serious, but it's not one that involves violence.
These issues are not just conducted as a proportionality assessment on a call it level playing field, or just an open question. That all of these matters are listed in the context of considering whether there are very compelling circumstances over and above. And one can see that, given the complexion of a particular case, some of them might very well be very compelling circumstances over and above. But these are not freestanding
they're not.
considerations.
That is not my...
No.
Absolutely. Absolutely.
So your suggestion is not that we look at this list of bullet points
No,
that comes from Strasbourg and say that that somehow replaces subsection 6.
no. I'm saying that these are the sort of factors that the fact finder will take into account
In deciding whether or not subsection 6 is satisfied.
Yes, that's it. So
And you're coming on to explain what exactly over and above means, are you?
yes,
Good.
yes. So these are the relevant factors that requires, and then you would also look at paragraph 52 that there is a margin of appreciation. The point is that whether it's really for the fact finder, the first judge, to conduct the balance and to make a decision. Now there was an apparent conflict of authority also as to whether rehabilitation was relevant. And you'll see a heading, rehabilitation, just above paragraph 53. And you'll see the Lord Hamblen says that it's common ground that rehabilitation is a relevant factor. And it then explains that, well, so far as the public interest is concerned, there are two aspects of public interest in this context. The first is protection of public, eliminating the risk of reoffending. But when an applicant has rehabilitated and there is no risk of reoffending, that addresses that aspect of public interest. But there is another aspect of public interest, which is deterrence, sending the message out that if you commit crimes, you will not be allowed to stay. Rehabilitation is not directly relevant to that factor. The point, the ultimate point is at 58 that it is relevant. The weight to be given to it in the proportionality assessment is a matter for the fact-finding tribunal. Paragraph 58. The fact that the fact-finding tribunal has attached less weight, little weight, greater weight, no weight would not be an error of law unless the conclusion is perverse. These are matters for the fact finder. And then you will see a quote at paragraph 58 which makes the point that I'm seeking to make, that if someone has rehabilitated, there is reduced risk of reoffending. That surely is relevant to proportionality exercise.
Yes.
If you then go to page 242, well, those are, and see paragraph 72, you'll see that Lord Hamblen identifies three principles entirely consistent with what I said in my skeleton and what Lord Justice Green ultimately said in Lord Justice Green said in Ulla.
Yes.
That one should proceed with caution.
Yes.
But this is what had happened in that case. The first judge allowed the appeal. The upper tribunal reversed the decision, and then there is an appeal to that court, to this court, and then to the Supreme Court. Just one final paragraph that may assist is 119, final page 254. The Supreme Court restored the decisions taken by the first-year tribunal. First-year tribunals in those cases said that, well, there is no error, there was no error of law, and makes the point, Lord Hamblen makes the point that if a factor is relevant, then weight given to it is a matter for the fact finder tribunal. Well, this is not limited only to rehabilitation, but to all relevant factors. So that is a matter for the fact finder tribunal. There is no error if the fact finder attaches greater weight to a particular factor, unless that is perverse or irrational. So this is Hache, Iraq. Second authority that the court will look at is Yalchin, tab 11. This followed Hache, Iraq. and the ambit of HA Iraq and NA Pakistan, where Lord Justice Jackson dealt with that particular point about over and above was considered head-on in this judgment. The appellant, this is a serious offender, someone who is sentenced to more than 4 years. Just like this appellant, he was successful at the first-year tribunal. The upper tribunal reversed the decision. There is then an appeal to this court, and this court reinstates the first-year tribunal's decision, saying that there is no error of law. And the reasons in this judgment are particularly relevant to the submissions that I will make. Now, if you go to page 260, you will see paragraph 14. And you will see that in 1 and 2, Lord Sandhill makes it clear the distinction between medium offender and serious offender. The serious offender is 2. And you'll see that Lord Sandhill has placed emphasis on the words that were troubling my Lord Justice Baker over and above those described in exceptions 1 and 2. And Lord Sandhill says that, well, those words are central to the main issue in the appeal. So that appeal is really about the words over and above. What had happened in that case, my lords, was that the first judge did not make any findings as to the 2 exceptions, went straight to subsection 6, conducted a proportionality assessment, allowed the appeal. The Secretary of State argued that that is wrong. The upper tribunal agreed with that proposition. And then, if I may just also ask you to look at paragraph 17, that is uncontroversial. The welfare of the child must be treated as a primary consideration. Paragraph 19, page 261, Lord Sandhill quotes the paragraph from HA Iraq that I've taken you to. It makes it absolutely clear that what is required is a proportionality assessment. Now, if you then go to page 263, and my lords will see a heading, decision. And under that heading, Lord Sandhill discusses the decision made by the first-year tribunal, the first judge. And the paragraph that I would ask you respectfully to look at is paragraph 29, which is at page 264. And this, in my submission, is acutely relevant on the facts of this case. So you will see paragraph 29, Lord Sandhill makes certain observations as to the decision by the first judge. That judge did not even refer in his decision to the provisions of the 2002 Act and the immigration rules.
But he did refer to the immigration rules, which are in the same terms.
No, sorry, the judge in Yalchin. Yes.
Yes, I mean, as I understand it, I mean, the immigration rules simply track what is said in the statute.
Absolutely. So, yeah, absolutely. But Lord Sandhill makes the point that it is good practice to...
but not an error of law. He says it's good practice, but not an error of law.
So if you don't sort of quote
Yeah.
statutory language, that's not an error of law. That is the point that is made against me. And then paragraph 2, there was no reference to any case law. There was no reference to... It is surprising to see extensive reference to case law in the decision. And then you'll see certain other observations that are made. the point that is Lord St. Hill is making at paragraph 2, that, well, it can be surprising to see a decision not referring expressly to the relevant case law. That's not an error of law. This is what this court said in A, Nigeria. So these are Lord St. Hill's observations as to the discussion by the first judge of law. If you then look at paragraph 32, where Lord St. Hill criticizes, in my submission, the first judge's decision. The first judge's decision, he said, was puzzling. The fact that a decision is puzzling does not necessarily mean that it's an error of law. And you'll see the criticism of Lord St. Hill as to the format of the decision, the language that the first judge used, and the way in which the first judge expressed himself. Lord St. Hill was making those points to say that, well, those are very unsatisfactory features, but not an error of law. Do not set aside a decision simply because you would express the decision differently or write a clear judgment. Now, if you then go to page 268, you will see a heading, Overview. And under that heading, may I ask you respectfully to look at paragraph 40. Now, in that case, just like this case, the upper tribunal reached a different conclusion on proportionality when it came to remaking the decision. But that, Lord St. Hill said, cannot constitute an error of law unless the first judge's conclusion can be categorized as perverse. This is the test that this court, in my respective submission, would apply. It is irrelevant that decision takers will sometimes differ in their assessment of the facts. A, Nigeria is the authority for that proposition. Perversity is the ultimate benchmark when it comes to the assessment of proportionality. Not failing to cite the relevant case law or the statute, or making a decision that is not clear and is puzzling, perversity. And this is the threshold that, in my respective submission, my lords will apply. If you then go to page 271, you will see a heading, the issues on the appeal. And at paragraph 50, Lord St. Hill essentially adopts the three principles as to judicial restraint from H.A. Iraq, now of course supported by Ullah. And referred to the relevant authorities. And then he then makes an important point, and that may assist if Malone Trent makes a submission to that effect. Well, the Secretary of State made a submission in that case was that, well, those principles also apply when this court is considering an appeal from the upper tribunal. That this court should not interfere with the decision made by the upper tribunal unless there is an error of law of that sort. But that, Lord St. Hill says, is false comparison. Because the question for this court in ground one is a pure question of law, whether the first judge made an error of law. So there is no question of deference to the upper tribunal at all. That is the question for my lords. And it is my lords who will decide that question. The two situations are not comparable. Paragraph 52.
It's a situation of respect rather than deference. Respect rather than deference.
Yes, but I'm not, with respect, even sure that when it comes to questions of law, the decision taken by an upper tribunal.
Just noting that he not surprisingly said that we could obviously give careful consideration to reasons.
Yes, careful, yeah. I'm grateful. So that is that. Now you'll then see heading failure to apply unduly harsh test. Now, this is where over and above comes in.
Good. Yes.
The Secretary of State, the upper tribunal said, well, over and above means that you have to first make a finding that the unduly harsh test is met, and you then go to subsection 6, and you then decide whether there is something over and above in order to qualify. That was the reason why first judge's decision was set aside, and the Secretary of State made that point. Now, if you look at paragraph 54, you'll see that it might be thought to follow from the fact that exceptions are self-contained shortcuts, that they have no role to play where a full proportionality assessment is required. But the very compelling circumstances must be over and above those described in the exceptions. And what is the effect of those words is what is discussed thereafter in the judgment. Lord Justice Hill then quotes from the judgment of Lord Justice Jackson in N.A. Pakistan. These were the two paragraphs in H.A. Iraq.
Yes.
And paragraph 57 is what those paragraphs actually establish. N.A.
Paragraph 57 of Yalchin.
Yalchin, yes.
Right.
So this is where, after quoting those paragraphs, Lord Justice Hill says, N.A. Pakistan thus establishes.
Well, he quotes the paragraphs that Lord Hamilton quoted,
Yes.
and then other paragraphs
Yes.
from N.A. Pakistan.
Yes. And then the conclusion, and this is the conclusion that in my respective submission you will follow, is that the effect of those paragraphs is that in a case where the very compelling circumstances of the claimant relies under section 117C6 include exception specified circumstances, it is necessary that there be something substantially more than minimum that would be necessary to qualify under the exceptions. But then the higher threshold is in the middle of between D and E, may be reached either because the circumstances in question is present to a degree that is well beyond what would be sufficient to establish a bare case. So in that sense, something more is required. But then, or, that is alternative, because it is complemented by other relevant considerations, which means a person's length of residence, rehabilitation, so on and so forth, or because combination of both. So over and above does not mean in addition to. It can mean if there is something more than mere exceptions, an applicant may rely on that. The applicant may rely on other factors, such as rehabilitation, length of residence, etc. Or combination of both.
You say that in addition, sorry, over and above means instead of.
No, I mean that to make that submission would perhaps would be an invitation to put to the court put a gloss on the statutory language, and I mean that is something that Lord Justice Hill considered in NA. So I'm not asking the court to do anything apart from simply adopting what Lord Justice Hill said between is in the middle of that paragraph as to how that higher threshold may be met.
But are you saying that this very densely packed paragraph 57 amounts to saying that you can establish very compelling circumstances even if you don't come within
Yes,
acceptable
absolutely.
or unacceptable?
Yes.
So you're better off with a sentence of over 4 years than you would be with a sentence of under 4 years.
No. So
Well, can we look at 117C?
yes. So
Suppose your client had been
Yes.
sentenced to 3.5 years rather than 6 years.
Yes.
How would section 117C operate?
Yes. entirely proper question and fair question, and I can understand why my lord asked that question. There is, as the courts have said, a drafting error in section 117, and the reading that my lord contemplates arises from that drafting error. That reading means that a serious offender, as my lord puts it, is better off than a medium offender. But in NA Pakistan, this court said that, well, that is a drafting error, and then sought to correct it by saying that subsection 6 is also available to medium offenders. Parliament could not have intended for an outcome where a serious offender is better off than the medium offender.
Well, you better show us that, because it seems to me to be rewriting the statute.
Yes. So this is what this court did very clearly on the Secretary of State's invitation in NA Pakistan. The Supreme Court in Hache was slightly troubled with that and made the point that, well, that is effectively rewriting the statute, but, well, that was the Secretary of State's invitation given to the court for proper reasons. So in a medium offender case, the medium offender will succeed if they show that there are unduly harsh consequences. But if there are no unduly harsh consequences and the exception is not met, then the fact finder will look at subsection 6 and decide whether there are very compelling circumstances. Although that subsection refers only to those who are sentenced to more than 4 years. So that provision is available to both medium offenders and serious offenders.
I'm sorry, I'm slightly losing the thread here. I understand your point arising out of NA Pakistan, which is that 6 is available to medium offenders.
Yes.
But are you making the submission that is the different submission that 5 is irrelevant to serious offenders?
I'm not making that submission. That 5 is.
So what in a nutshell is your submission about the relevance of 5 for serious offenders?
Yes. Lord, if you look at paragraph 60 of Yalchin, that is my submission.
6C.
60,
sorry.
And that is the submission that I need to make on the facts of this case. It is not necessary, as a matter of law, for a tribunal in a serious offender case to make explicit findings in the claimant's favor on questions under the 2 exceptions. So it can be relevant on the facts of a particular case. For example, an applicant may say that, well, deporting me would be unduly harsh to my child. But in addition to that, I've been here for 40 years, I'm not offended, I've rehabilitated, look at everything, and there are very compelling circumstances. Or he can say that, well, forget about the exceptions, just look at subsection 6 directly, conduct the proportionality exercise. The impact of deportation would not be unduly harsh, but it would be serious. But when you will consider that seriousness with all other relevant factors, you will conclude that there are very compelling circumstances. So I cannot possibly submit that subsection 5 is completely irrelevant in every single case. The submission that I do make is that it is not necessary, as a matter of law, for a tribunal to make a finding that exceptions are met before the tribunal allows an appeal under subsection 6.
So that comes back to over and above. What does over and above invites a comparison between 4 and 5 on the one hand and 6 on the other, doesn't it?
Yeah, absolutely. I accept that, yes. So, but what it actually means, there are 3 ways an applicant can succeed under subsection 6.
Right.
So the first is to say that the 2 exceptions are met and the circumstances And there are features
to a higher degree than they would have to be met for 4 and 5.
Yes. So that is
So the only factors relevant are those covered in 4 and or 5, and in this case they are met to a higher degree than they would be required to be met for
That's
4
it.
and 5. That's
But-
situation 1.
that is situation 1. The second situation would be to say that, well, those exceptions are not met. There are other matters. Length of residence, rehabilitation. And those matters, when considered in the round, are compelling enough over and above the 2 exceptions that justify allowing my appeal. So think of this. I mean, this is a good case to test the argument. A person has been in this country for 42 years. 42 years. It's perfectly proper and open to a fact finder, irrespective of 2 exceptions, to say that, well, length of residence, together with other factors like rehabilitation and seriousness of the offending, mean that there are very compelling circumstances, or sexual abuse as a child mean that there are very compelling circumstances. So that is the second scenario in which a person can qualify. The third scenario is that a person can mix and match, rely on both matters, rely on some features falling within the exceptions, some feature falling outside the exceptions. That is the effect of over and above.
So it's really not just over and above, it's over, above and beyond. Oh, and or beyond.
Well,
Over and above, it does sort of seem,
yes.
doesn't it,
Yes.
to tie
Yes.
subsection 6 to subsections 4 and 5.
Yes,
Where
that's
those words do. Because you're saying these authorities are clear,
absolutely.
are binding on us that it doesn't.
Absolutely. And there's a good reason why the Supreme Court and this court in Yelchin said that cannot be right. Because if the court adopts that approach and links proportionality assessment to the 2 exceptions, that would be contrary to the Strasbourg case law.
Contrary to Strasbourg.
Precisely.
The list, the bullet point list.
Absolutely. Absolutely. You
So
have,
you say the effect of Strasbourg case law is it's all discretionary in the end, however long the sentence, and whether the appellant has any of the characteristics in subsection 4 or subsection 5. Just there's an overall broad brush.
or something else.
The FTT judge is entitled to say, I think the circumstances are very compelling,
Yes.
and it's not for anybody else to interfere.
Yes. Yes. That is what.
Is there a specific authority, a sentence or binding on us, which confirms that? And that, so you've given us three categories. You've given us the category where
Yes.
all the relevant factors fall within the 4 and 5 exceptions categories.
Yes.
Cases where they overlap,
Yes.
and cases where there are purely factors which are not in 4 and 5.
Yes.
What can you show us an authority
Of
on
course,
the
yes.
third of those?
My apologies.
No, there was nothing about the 4 and 5 exceptions at all.
Yes, Yelchin, Lord. If you look at page 274, I was actually sort of reading from what Lord Sandhill had said, or summarizing the effect. If you look at paragraph 57, if you look at 1, 2, 3, 4, line 8, that higher threshold may be reached, and you then have sort of 3 situations set out, either because the circumstances go well beyond the exception, or complemented by other relevant circumstances, that is rehabilitation, etc., or because the combination of both.
Well.
The circumstance in question is
4 or 5.
sorry, yes, something is 4 or 5.
Where is there the? Where does it say? I may be misreading it. Or where does it actually say? A factor which is not covered in 4 or 5, but to a high degree. You're saying it's covered in the first of the
Yes.
options, are you?
Yeah, yes. And if yes, paragraph, if you read then paragraph 58, there is nothing at all surprising about this, at least in the case of a serious offender. Where is it? Yes, paragraph 60, yes. So this is where...
Well, actually, forgive me for interrupting you. 57 begins by saying, any Pakistan established the effect of the over and above requirement is that in a case where the very compelling circumstances on which a claimant relies include an exception specified circumstance, it is necessary, etc. So doesn't that, on all the exceptions, all the circumstances covered in 57, cases where there is an exception specified circumstance? I mean, please,
yeah.
I've misread that.
I mean, could this may or may not help, but let's take an instance where, for example, somebody is about to be deported to
yes.
Sorry, could I just throw this out, see if it helps? That let's suppose somebody's got an extremely serious health condition.
Yes.
I mean,
Yes.
it has a health condition which is being treated here and is of maximum severity,
Yes.
but is being deported to a country which has an equally good health system.
Yes.
They wouldn't, would they, fall within the exceptions?
Yeah.
But they may very well
Yes.
lead to a conclusion that it would be
Yes.
a very compelling over and above.
Absolutely, yes. Yes.
And it would be an Article 3 case rather than
No,
Article 8.
where Article 3 threshold is not met.
All right.
And then, you know, what if a person has lived in the country for 50 years, 60 years, 70 years?
Right, so you're talking about the 80-year-old deportee.
Yes, who has lived here all his life. So those are the sort of matters that would not fall within the exceptions. But it's perfectly legitimate for the fact finder to say that, well, there are those very compelling circumstances.
Or is there any case in which it has been expressly held that a foreign criminal in the 4 years and above class can avoid deportation under the very compelling circumstances clause, even though he does not qualify under exception 1 or exception 2?
So Yalchin is that case where the person, serious offender, the two exceptions were not met. The judge still allowed the appeal on the basis that there are very compelling circumstances. The upper tribunal set aside the decision on the basis that, well, you have to make express findings on two exceptions. So I've shown you paragraph 57. If you look at paragraph 60, where that submission is considered head-on, Ms. Manion for the Secretary of State argued cogently in support of the upper tribunal's conclusion. This is page 257. But after careful consideration, I do not believe it is correct. I do not believe that it is necessary as a matter of law for a tribunal in a serious offender's case to make explicit findings in the claimant's favour on the two exceptions.
So 1 and 2, Roman 1 and 2, in the last line of 60, that's Roman 1 and 2 back at the beginning, is it? Where do we find the Roman 1 and 2 he's talking about?
Paragraph 59.
59, is it? No, I'm against him, sorry.
And then, just to illustrate the point, if you then look at the reasons why Lord Hunter rejects those points, 61 and 62. 61 is an exception overlap case, and paragraph 62 talks about a holistic assessment of all relevant circumstances. And this fact arises, of course, from Hache Iraq. And then if you still have doubts about the submissions, then may I ask you to look at paragraph 64 of Yalchin, where paragraph 64 of Yalchin, you will see that, I referred a lot of this Underhill to what he had said in his judgment in Hache, Iraq, and then made a submission to that effect. And then he makes the point again that the spirit of what he said does seem to be to the same effect. That the focus must be on the conclusions under subsection 6, and explicit findings on particular matters feeding into the conclusions are not relevant. In all cases required as a matter of law.
Just going back to the end of 62, which you paused on, reading from letter E, it would, in my view, place an unrealistic burden on tribunals for them to have to decide and specify in every case whether the something more consists of the exception-specific circumstance being present to an elevated degree, or to some other circumstance, or circumstances, or to a combination of the two. So this comes back to the point that, I mean, this court has held, as I understand this judgment, that 4 and 5, the exceptions, do not provide the only gateway to 6.
That is the submission, yes. Not the only gateway, but I'm not, of course, for that reason submitting that they are completely irrelevant. They may be relevant in one case, but they, as Malord puts it in my submission entirely accurately, is that they are not the only gateway to succeed. What ultimately requires is a proportionality assessment, looking at all the circumstances of the case as set out in the European case law.
So one might think that one could search for a long time to find a case where you would succeed under 6 without having at least something strong to say in relation to the exceptions.
Absolutely.
But that's a matter of assessment, not a matter of law.
Yes. So there is a very strong, significant public interest on one hand, but on the other hand, there has to be something really compelling to outweigh the public interest. But it is for the fact finder to weigh all relevant consideration and do the balancing exercise. The appeal court can only interfere if the decision is perverse, if it is so bad that no reasonable decision maker could have resolved that balancing exercise in that way, or if there is some other misdirection.
So are you saying that the error of law in this case, or the UT's assessment of the error of law, was fallacious on the same basis as in Yelchin?
Yes. So the upper
We're on all fours. You say the upper tribunal made the same error that law just identified in Yelchin in 59 and 60.
Yes, and the upper tribunal made the same error that the Supreme Court identified in Hache. Well, the upper tribunal did not like the first-year tribunal's decision, took the view that, well, it wasn't properly expressed. The reasons were not great, and decided to set aside that decision. And the appeal, of course, you see, succeeded. If you look at the last paragraph 74, Lord Sandhill says that, well, the decision can be criticized. The first judge's decision can be criticized in various respects. He also said that he was able to understand why the upper tribunal decided that that decision is so bad that it cannot stand. But in the end, Lord Sandhill says that shortcomings in a decision are not an error of law.
Can we just look at the facts in this one? Because I'm not sure that I've really absorbed it. The appellant gets 5 years, 4 months for a firearms offence. And
Yes.
what was the FTT's? What was the crux of the FTT's?
Well, the FTT, rather than looking at the exceptions, went straight to subsection 6. And if you go to page 263, you'll see a heading, decision, and under that heading, Lord Sandhill quotes from the first year tribunal's decision. And there was there was a child who had particular needs, but the impact would not be unduly harsh. The fact finder looks at the circumstances of the child, considers all other relevant matters, and then resolves the proportionality assessment in the appellant's favour. And if you wish to see a conclusion, this is paragraph 33 of the judgment.
Yes.
So this is from the upper tribunal's decision. There's a serious offence, but the appellant has spent time in prison. He's a hard-working individual, has rehabilitated, established 2 businesses, is helping the family. The sponsor is estranged from the family members. Welfare of the children on the next page. A strong family life. Welfare of the children. And said that, I find that removal would be disproportionate in all these circumstances, right at the end of that quotation, paragraph 43 within the quotation.
Looks to me as though what the FTT judge must have thought but didn't spell out is that in relation to child D in particular, speech and language and behavioural issues.
Yes.
32(3) of Lord Justice Underhill's judgment. The judge is intended to make the point the extent of D's emotional dependence on the appellant is exceptional. And then at the end of the cited passages from the FTT's judgment, in considering the strength of the appellant's family life in the UK, noting the particular significant circumstances arising out of his relationship with D, noting D's significant learning and behavioural issues, and noting the best interest of the appellant, I find the appellant's removal in the UK would be disproportionate.
Yes.
So that must mean, if the judgment was to be upheld or restored as it was, that the judge is finding that the effect on D, a qualifying child, would be unduly harsh, and then so much so that it's compelling circumstances.
Yeah.
You say just compelling circumstances, jury question, unappealable on the part of the same.
This is precisely what the Secretary of State was arguing.
Well, I know, but
and this is what the upper tribunal said, that
yes.
you must look at the exception first.
Yes.
And decide whether the consequences will be unduly harsh.
Yes.
And then look at subsection 6. You haven't said that the impact would be unduly harsh. You have gone straight to 6, and that is wrong. But Lord, if you look at paragraph 33 of the judgment of Lord Underhill, which says
yes.
Paragraphs 43 and 40 contain to be the core of the first year tribunal's reasoning. And I do, Lord, submit that, well, the welfare of the child wasn't really the only factor on which the appeal succeeded. The core included a number of other matters, and you can see immediate parallel with this decision.
There were children 11 and 10, weren't they?
Yeah, so, the judge started by saying, not with the children, by saying that, well, this is a hard-working individual, established businesses.
No, just as a matter of fact, picking up earlier in the judgment, I think the children were aged around 11 and 10 or something of that sort at the time of the appeal, younger
Yes.
at the time of the decision.
Yes. But but the submission that I'm making is that appeal did not succeed simply on the basis that welfare of the children requires that there be no deportation. The judge looked at all the matters, conducted a balancing exercise, weighed those difficulties into the balance and made the decision. Considered, as I said, the life in this country, the businesses, what he was doing, employment, the support that he was providing to the family, low risk of reoffending, residence in the country, rehabilitation, and then said that, well, when I look at all those circumstances, I find that the removal would be disproportionate.
Yeah. Well, Lord Justice Underhill's analysis at paragraph 67, which I hadn't previously read, does seem to be on the same lines as my impression. The Yalchin is not a case where this court is saying it doesn't matter whether either of the exceptions apply. You can go straight to compelling circumstances, surely. What Lord Justice Underhill is saying, it's obvious that the FTT judge did regard the effect on D of the appellant's deportation as unduly harsh, and the upper tribunal were wrong to say, because there was no explicit finding to that effect, therefore the decision must be set aside.
On the facts of this particular case, well, this causes me no difficulty. I mean, because in this case there is actually a finding that the deportation would be unduly harsh. The submission that I was seeking to make, my lord, was that the law does not require a fact finder to make findings on the two exceptions before the fact finder allows the appeal. And what subsection 6 requires is a proportionality assessment in line with Strasbourg case law.
The law doesn't require going through the exceptions hoop on the way to compelling circumstances.
1 and 2, because a point in this case is actually more about exception 1. So the law does not require the fact finder to make findings on either exception 1 or exception 2 before conducting the balancing exercise.
On compelling circumstances.
Right. Do we need anything else from Yalchin?
That is all. So may I then turn to the facts
Yes.
and address you on the 2 grounds with submissions that I've made in mind. May I take you to the first year tribunal's decision, page 120 of the appeal bundle. If you go to page 122, you will see a heading, the evidence.
Yes. And it's right, I think, isn't it, that the findings of primary fact by the FTT have not been disputed on appeal. That the upper tribunal, even if it was right, which you don't accept, to held there was an error of law and remake the decision. There was not any error of law in the findings of fact.
That is right, yes.
They said all that's changed is that Alexander is older now, and we don't accept the finding of undue harshness, but all the findings of fact as such are accepted as common ground.
That's right, but the point the upper tribunal makes essentially is that, well, these findings do not justify the conclusion, and that is the test that my lords will apply. Is it so bad that no reasonable judge could have come to this decision. Of course, bearing in mind the 6.
Well, or a misdirection.
Or a misdirection in law. But this case isn't really about misdirection in law as such. I'll explain why that is so. So, may I just start with the evidence first?
So you're going to have to explain that.
That there is no misdirection.
Yes.
Yes, I will. Yes.
All right.
Yes. So page 122, you'll see a heading, the evidence. Now, the appellant gave evidence. He was cross-examined. His son gave evidence. And his partner gave evidence. And then the judge reassures the reader at paragraph 20 that I have considered all this material before deciding this matter. So he's looking at everything that is in the evidence. You'll then see a heading, findings. So what I propose to do is to focus first on the law, where there are self-directions, and explain why there is no misdirection in law, and we'll then look at the findings. Now, the relevant self-directions, the first relevant self-direction is at paragraph 23. The judge recognizes that the effect of the statute is that deportation of a foreign criminal is conducive to public good. Paragraph 23 is the first self-direction. That is entirely correct. The judge recognizes that deportation is conducive to public good. The judge then expressly refers to sections 117A and D. The judge in Yalchin did not do that, but this judge does, and says that Parliament's views are set out in those provisions. It is for the appellant to identify very compelling circumstances with respect to why he should not be deported. An express reference to the statutory provisions and to the very compelling circumstances test.
But you mentioned of over and above.
Yes, but in Yalchin, the judge had not referred even to statutory provisions. But that matters not for the reasons that I'll come to. I mean, if you accept my submissions on law, that over and above does not mean in addition to, then that makes no difference. Very compelling circumstances. He then recognizes that this is a serious offender. This is paragraph 25. And that means that this person cannot qualify simply under the exceptions. This is, in my perspective, an entirely apt self-direction, in line with HA Iraq, in line with Yalchin. I must nonetheless consider whether there are very compelling circumstances such that he should not be deported. Paragraph 5 of HA Iraq, very compelling circumstances means circumstances that...
It's almost as if he considers that subsection 6 is a tailpiece to subsection 5. Instead of being a step up, that it's a sort of add-on. It's a step up.
Lord, I have of course made submissions.
Yes, you have, but I mean, and so, I mean, you were taking us to 25 and 26 by way of reassurance, but do they not represent something of a difficulty for you?
Lord, if you look at 25, in 25 he says that the length of sentence, 4 years, imposed upon the appellant precludes consideration of Article 8 as articulated in 399 and 399A. Yes. These are exceptions. Yes. He recognizes that this is essentially step up, that this is not a medium offender, he's a serious offender. And then the judge has to decide whether there are very compelling circumstances.
What's he considering under 26 to 31?
So 26, he says that I have to decide whether there are very compelling circumstances. And then from 27 to 32, he simply, in my submission, clears his desk and says that, well, the appellant has stomach cancer, there are mental health issues, friendships, but I'll put all that to one side because none of that would amount to very compelling circumstances. Is right to do so. He then looks at, you'll see a heading, Article 8 outside the immigration rules. That means Article 8 outside the two exceptions in the immigration rules. Sorry, before I go further, of course I understand that my lord asked a question about self-directions and asked me to explain why there was no self-direction. That, my lord, you hear from a learned friend, that isn't an issue. The upper tribunal did not set aside the first year tribunal's decision on the basis that there was a misdirection in law as to subsection 6. The upper tribunal set aside that decision, saying that reasons do not justify the conclusion, not that there was any misdirection in law. And there wasn't, in my submission, if you then look at the rest of the decision. Now, if you then look at page 148, the judge says at 33 that his job is to...
Yes, but sorry, I must have misunderstood something. You've got paragraphs 26 to 31, the finding at 30 that all in all I'm not satisfied. These are compelling circumstances. That's the appellant's physical health, mental health, and private life of his own.
Yes.
Then there's 32, something has gone wrong with, because it's a part sentence which doesn't lead anywhere. And then he changes topic to Article 8 outside the immigration rules. So what was the what's the missing heading for 26 to 31?
Things that do not matter. I mean, one can criticize this decision as much as one wishes, but I understand. Yes, what is missing is things that do not matter. Probably.
All right. So right, I don't want to be unfair to the judge. It looks as though 26 sets the scene for everything that follows.
Yes.
Then he deals with some issues in 27 to 29 and says, I'm not satisfied. These are very compelling circumstances. So on those issues, he fails.
Yes.
And then cross out 32, something's gone wrong, but he seems to be saying, I now turn to other issues.
Yes.
Okay.
That must be the right reading of the judgment.
Right.
Well, I mean, yes. I mean, this isn't, of course, the right way to write the decision and to sort of compartmentalize things in this manner.
I'm struggling with what 33 and 34 are doing in this.
33 and 34. So 33 says that.
I mean, just to explain why I say that he's embarked upon what one would expect to see, which is at 26 the very compelling circumstances analysis, and he's taken it to a certain degree. Yes. And then I think what we need to understand is where is it going with 33 and 34? Yes. That appears to be almost dropped in from another case.
Yes. So at 33, in my submission, the judge is setting out the scene. The judge is saying that what follows is a balancing exercise. That my job, he's saying at 33, is to balance the conflicting interests of the respondent and the appellant. That is right. 34, this in my submission is relevant because here the judge reminds himself that the more serious the offence committed by a foreign criminal, the greater is the public interest in deportation. And he is reminding himself of the very significant public interest in deportation of foreign criminals. And he is reminding himself what, that in my submission, that unduly harsh is an elevated standard.
Uganda was a medium level offender case, wasn't it?
Well, Uganda, yes, was a case where the unduly harsh test was grappled with.
It just seems strange that having directed himself that he wasn't concerned with the exceptions, he then puts in 2 paragraphs which are all about.
Yes.
There it is.
Yes. Yes. Perhaps he was using a template that came from another decision. Yes, but what one gets from these 2 paragraphs, I respectfully invite you to conclude, is first that the judge recognized that his task was to conduct a proportionality assessment. 33, and in conducting the proportionality assessment, the judge said, that he knew that there is a compelling public interest in deportation of foreign criminals. Then from paragraphs 35 to 45, the judge makes findings of fact about eight different matters. The first matter is at paragraph 35. Here the judge makes the finding as to the appellant's residence in the UK, 41 years, the fact that the appellant arrived here as a child, that he was hoping to be adopted, he wasn't adopted, he instead of becoming a part of a family unit, he then assimilated in a cult, he was sexually abused as a child. Final sentence of that paragraph, a finding that is not challenged. So he's a person, in my respective submission, with a traumatic childhood experience. So that is the first point, the first finding. The second point the judge deals with in paragraph 36, the appellant's previous and current relationships. He previously had a partner, the child's mother, and he is now married to another person, the person who gave evidence, the British citizen. The child is also a British citizen. The third point the judge deals with is at paragraph 37. That concerns the circumstances relating to the appellant's child, his age. The judge makes findings about the child's confrontation with the mother, and then makes a finding at paragraph 37. That says, well, he's an immature 17-year-old person. There is evidence from social workers. There has already been a disruption in the family, in the child's circumstances. And final sentence, that both parents, the appellant including, were working hard to stabilize the child's emotional development at this important time. So the appellant was playing a key role. The fourth point is in the next paragraph, paragraph 38. This is where the judge makes findings as to the needs of the child and his experiences. Acknowledges that, well, the child will benefit from the presence of both parents. That's not enough. He says that the child's experiences in the past few years make this a desirable proportion. And he then explains why that is so and says that that is confirmed by presentation of evidence. The fifth point is in paragraph 39. This is where the judge makes findings about the relationship of the child with the appellant and the role that the appellant plays in the child's life. He was initially absent. He now plays an important role. The evidence of his genuine difficulties when one or other parent is removed is picked up, and the judge then refers to the confrontation between the child and the mother and the nature of that confrontation. Sixth point, paragraph 40. The feelings and difficulties that the child would face without the appellant.
But does that mean that only childless offenders can be deported?
Not at all, no.
Well, if the finding in paragraph 40 is justified, can you describe a family to which this would not apply?
This would. So there are two submissions that I will make. The first is that if Lord makes a decision on that basis, my Lord would be, in my respectful submission, would be using a notional comparator that the Supreme Court said should not be used. So there is no standard notional family where the difficulties would be faced in any event, and then to seek to compare the facts of this case to that. So there is no submission that problem with that hypothesis. But keeping that to one side, I would accept with no hesitation that it would be perverse for any judge to allow an appeal on that basis alone, on the basis of paragraph 40. If this judge had allowed the appeal on that basis alone, I would not have been defending this decision. But he made 8 different findings, and this is one of the 8 findings. Paragraph 40, the feelings of the children, feelings of the child, frustration, anger, etc. The seventh finding is
it significant that he applies the unduly harsh yardstick?
Yeah. So he there makes a finding that it would be unduly harsh. That the consequence of the deportation would be unduly harsh on the child. But he shortly, I mean, it's quite clear, and I'll show you other paragraph. I mean, he did not allow the appeal on that basis. He could not have allowed the appeal on that basis. But he made a finding that the impact on the child would be unduly harsh. And the reasons for that finding are not only in paragraph 40, but also in the other paragraphs that I've taken you to, 37, 38, 39, and 39, where the judge refers to the oral evidence that he heard from the child, from the parents, evidence from independent social worker, and then makes a finding that the impact would be unduly harsh on the child, but does not allow the appeal on that basis. He then says at 41, this is the 7th point, that there is low risk of reoffending and there is positive evidence of rehabilitation. The Supreme Court tells us that this is relevant. So that means that in this case, the public interest to protect public does not really arise. So there's no risk that this person will offend again. So the public interest that the judge is looking at is deterrence. So low risk of reoffending and rehabilitation, and serious his offending is. He has not been convicted of violent offences, and there is no risk of causing serious harm to third party. That's the 7th point. The 8th point is at paragraph 45, which is, it deals with the nature and seriousness of the offence, says that, well, the offence is really very serious. The sole purpose was financial gain, and very considerable financial gain, attempts to obtain loans, and these are not victimless crimes. So he understands that that is quite serious. And he
Says,
also,
I do not find it, and it must be a misprint, for any very compelling circumstances in those events.
that is an obvious error in drafting.
Yes, but he seems to be saying that he doesn't find that it's very compelling circumstances that these were financial crimes rather than violent crimes.
What he's saying in my respective submission is, in my submission is that, well, these are serious crimes, and there was no justification for those crimes. And you will see from the final sentence that rehabilitation attempts prior to 2014 have been unsuccessful. So he acknowledges the seriousness of the offending. So eight different matters, 8 distinct matters. So these are 8 matters that he considered. You'll then see heading balancing exercise.
The only possible sense one can make out of the sentence with the misprint in it is that it can't be a very compelling circumstance that these are not very serious offences.
Yes.
So it's hard to see the thought process that leads you to be considering that as a prospect.
Yes. So one can contemplate a judge who would allow the appeal, saying that, well, these are financial crimes, and they are not as serious as other crimes.
So really the words very compelling circumstances have no business to be in that sentence. Really he's saying, I'm not accepting any submissions based upon these not being serious offences.
Yes.
Right. And we'll see how that comes into the analysis later on in the judgment.
In the balancing exercise, yes. Well, yes, and that, yes, and if you read that paragraph as a whole, starting with the first sentence, the point that he's making is that, well, these are serious offences. Now, there is then a balance. So after making findings of fact on 8 different matters, he then conducts a balancing exercise. He then reminds himself again at 46 that more serious the offence, the greater is the public interest in deportation. The offending, while serious, is at the lower end, he says. That is not to say that the offending is victimless, but this isn't violent offending, and this is reflected by the length of the sentence.
But is MM Uganda the starting point for this balancing exercise at all? It's not, is it? It's subsection 6 is the starting point for this balancing exercise.
No, the balancing exercise is sort of proportionality exercise. So what he is doing in my respective submission is, after sort of setting out all relevant matters, the purpose of this paragraph in my submission is to remind himself that committing crimes is a serious matter. The more serious the offence, the greater is the public interest in deportation.
But that's not the principle that he's supposed to be applying.
No, this is actually, my lord, forgive me, this is the principle. So this is subsection 1 of section 117C. So section 117 starts with that. If you want to look at that provision again,
it's now in the statute, but it's the same. The more serious the offence, the greater the public interest. That's now in section 1171.
Yes, sorry, section 117C2.
117C.
So you get to so you get to exceptions and proportionality by first acknowledging that, well, the more serious the offence, the greater is the public interest. So he starts. You have it's entirely my fault. I focused on the 2 exceptions and subsection 6, but Subsection 1 says deportation of foreign criminals is in the public interest. And subsection 2 says more serious the offence, the greater is the public interest. The judge recognizes both. I showed you part of the decision where he says that deportation is conducive to public good, and makes the point again that more serious the crime, the more compelling interest is what is in deportation. And then paragraph 47, he balances, in my respectful submission, everything up. He says, and this is really important, and it makes absolutely clear that he wasn't simply allowing the appeal on one ground. If you look at line 3, given my findings above, findings, not a single finding as the upper tribunal thought, but findings about 8 different matters. He then says that, well, in the light of findings, and then he says, I'm satisfied that there will be very detrimental effect on the child. Finding that was open to the judge. And then says, after considering the evidence, deep resentment, frustration the child is facing. Given we have been here before in the circumstances described at paragraph 39 above, and this is the paragraph where the judge deals with the confrontation, and the judge then says that I'm satisfied that deportation would both be unduly harsh and very compelling. And he then refers expressly to section 117C. 2 findings, unduly harsh and very compelling. And allows the appeal on that basis, paragraph 49, proportionality assessment. In my respectful submission, there is no error of law in this decision. I criticize this decision because of the way in which the judge expressed himself, the structure of the decision, but it cannot be said that this is a perverse conclusion, a conclusion that no reasonable judge can arrive at, or that these 8 findings cannot possibly justify the decision. Different judges do come to different and legitimate decisions. The authority from the Supreme Court is that the fact that a decision appears to be generous does not mean that it is wrong in law. It cannot be said in my submission that this is a perverse decision. So no error of law for these reasons. If I may then show you the upper tribunal's decision and identify the reasons. Sorry, before I do that, can I just show you the grounds of appeal, the grounds on which the Secretary of State challenged this decision. So page 115. These are the Secretary of State's grounds of appeal. The earlier part is simply a recitation of the case law. So paragraph 9 is the first point. It is submitted that the FTT's reasoning simply does not establish the high threshold. This is, in my submission, a classic disagreement with the decision, or a perversity challenge. No adequate reasons as to the unduly harsh consequences.
It may not matter, but this is all under ground 1, making a material misdirection of law.
Yes.
And failing to give adequate reasons.
Yes. And ground 1 is about the unduly harsh testing.
Yes.
Well, you've quite rightly taken us through the FTT position, and if you're right that there's no error of law, it doesn't matter what the pleaded grounds were. I cut this short when I was reading the papers, rightly or wrongly, by looking at the grounds on which the Home Office were given permission to appeal, which are at page 110.
Yeah.
And Judge Gumsley said, I'm satisfied it's arguable the FTT judge made a material error of law, one, in the way he approached the various tests both of undue harshness and very compelling circumstances over and above the unduly harsh threshold, and or two, providing inadequate reasons for finding as he did. I mean, you've covered your ground one and you're saying that both these are wrong, but we're not going to gain, are we, by going through the grounds of appeal to the upper tribunal?
I'll move on. I thought I would just simply show you what the Secretary of State was arguing. Yes, but if my Lord finds that 110 is a convenient summary of the grounds, I have no issue with that. But when I'll show you the error of law decision, I'll show you that.
Yes. Well, if you're right about if you're right on your ground one,
and it matters not.
Then it goes no further.
Yes.
Because if the FTT judge made no error of law, then the upper tribunal has no business to interfere. However, if you're wrong on ground one, then you have ground two as a fallback.
Yes, but that of course concerns the remade decision.
Yes.
Yes, but I'll show you the error of law decision. My Lord is absolutely right that what the upper tribunal has said doesn't matter really, because it is for my lords to decide whether there is an error in the first judge's decision. But as Lord Peter Jackson says, it's proper to have out of respect to the upper tribunal, it is important relevant to look at their reasons.
Yes.
Because you'll see that I'll explain why their reasons were not apt. So the error of law decision is page 98 of the bundle.
Yes.
I said it matters not, so I'll just go through this decision very quickly and take you straight to the actual reasons. If you go to page 103.
This is all quoted, isn't it, in the subsequent judgment as well? Subsequent decisions.
Yes, it was attached. Page 103.
103.
Yes, page 103.
Thank you.
So.
You tell me, Mr. Malik, just out of interest, because you have more experience with this than I do. In the error of law decision is made by a two-judge panel.
Yes.
And then one of them, the salaried one,
yes,
as it were, makes the further remade decision. Is that usual?
Yes, it is, because you'll see that there was a deputy judge sitting with the upper tribunal judge. There are issues with availability, etc. So a deputy judge sits on a sort of part-time basis.
But he's sitting as a two-judge panel, usual.
Yes, on the error of law
Error
stage.
of law.
What usually happens is that there is then a transfer order that the resident judge makes, permitting the remade decision to be taken by a single judge.
Right. All right. I'm sorry to have interrupted you. So we're on the error of law decision.
Yes. So page 103, paragraph 46, and these are the two reasons given by the upper tribunal for finding an error of law. So no misdirection in relation to subsection 6. No misdirection. We are not satisfied that he gave legally adequate reasons for considering that there are very compelling circumstances. So, no legally adequate reasons. And second, there is a misdirection as to the unduly harsh test. Now, the reasons are not inadequate. And there is no misdirection as to the unduly harsh test. There's no misdirection. But the upper tribunal actually misdirected itself as to the law. And if you look at 47, you will see why that is so. So the upper tribunal essentially makes the point that the Secretary of State made unsuccessfully before the Supreme Court, based on KO Nigeria. So upper tribunal also picked those paragraphs from the judgment of Lord Conworth in KO Nigeria. And look at the final sentence, please, at 47. The regime necessarily contemplates the prospect of separation of a child from a parent who is to be deported, and the natural feeling that would, in a child, in many, if not most cases, which may include anger and frustration. This is what the Secretary of State was saying, that, well, there is a notional comparator. Any child would face some difficulty when facing deportation. This is what Lord Conworth was saying. And therefore, unduly harsh test means something more than what any child would face.
Yes.
The Supreme Court said that is wrong. It is an error of law to use a notional comparator to make the assessment.
Then how do you make the assessment as to what unduly harsh means?
Absolutely. Well, Lord, well,
you say it's just in effect a jury question.
No.
Do I, the judge, think it's unduly harsh?
Yeah. So the question that is troubling you questioned many different judges of this court, and they all are some. And Lord Justice Baker is of course familiar with the area, and so is my Lord Justice Peter Jackson. Different judges sought to grapple with this, and if you don't use the comparison, then how do you make the assessment? Was the concern in many judgments, but then this was then resolved ultimately by the Supreme Court for the 6 different reasons that I showed you, that it is actually a matter of evaluative judgment for the decision maker. The fact finder will look at the facts, will make an evaluative judgment and make a decision without notional comparator.
Yes. So is it unduly harsh for this child? Not is it? What is the comparison between this child and some other child?
Yes. But precisely, and this is what Lord Sir Peter Jackson said in Hatch Iraq in his short supplementary judgment, which was then endorsed by the Supreme Court. So you look at
all they're saying here, surely, is it's always harsh. And how could it not be harsh for any child of any age to be told your father is going to be deported to Zambia, or indeed anywhere else, and unless you travel, you won't be able to see him for the next 10 years. Of course it's harsh.
It will be harsh, but if you then use that as a comparator to consider the facts of this case, to see whether there is something more than what any child would face, that the Supreme Court has said is the wrong approach. It is error of law to do that. You cannot use notional comparator.
So you just
it's a matter for
stick your finger in the air and say, do I consider that this is unduly harsh?
So the judge will make findings of fact and then conduct an evaluative judgment. Evaluative judgment is what the Supreme Court said. Evaluative judgment. It is for the judge to decide what would be unduly harsh for this child without comparing this child with any child or with a baseline.
Is that what the upper tribunal are doing here?
In my submission, yes, at 47, the upper tribunal is quoting the same paragraphs from KO Nigeria, where Lord Conworth appeared to have said that a notional comparator is needed, but Hatch Iraq says that it's not. And then 48, it is said that the first year misdirected itself when concluding that the prospects of anger and frustration could meet the high threshold. There is no such misdirection. The judge conducted an evaluative judgment, looked at the circumstances of the child, not simply anger and frustration in isolation. The child's age, confrontation with a mother, independent social workers' evidence, the role that fathers play, and then concludes that the consequences would be unduly harsh.
Suppose Alexander had been 6 months older at the time of the FTT hearing. Would that make any difference to the case? He wouldn't then be a qualifying child within section 1175.
No.
But you say that doesn't matter.
He would be a qualifying child even if he was 6 months old.
6 months older, 18 years
Oh.
old.
Oh yes, of course, yes. Then he's no longer a qualifying child.
Yeah.
And therefore, in a medium offender's case, demonstrating undue harshness would not be enough. But my lord, this case ultimately is not about, as I was sort of seeking to demonstrate throughout my submissions, about the unduly harsh test. This is one of the findings the judge made that he was not required to make as a matter of law. So you do not, in my submission, set aside the decision because he made a finding that he was not required to make. But the definition of the child is in section 117D. Anyone who is under 18, British citizen, is a child. But the question for my lords, in my respective submission, is whether the decision that the judge took fell within the range of options available. Was there an evaluative exercise, and whether there is a decision that is not perverse. So my lord may take the view that this is an odd decision, it's a generous decision, it's not perverse. There is an error of law in my submission at paragraph 49, although I need not to demonstrate that there is an error of law. The judge says that and this really is why, what really matters to this case, why the very compelling circumstances finding was set aside. It matters not the finding of undue harshness for the reasons I've given. Very compelling circumstances must necessarily involve something more. Something more. Line 4. Something more. If that is, in my submission, flatly inconsistent with Yalchin, something more in addition to is not what over and above required. And then paragraph 50, yes. Paragraph 52.
Why is something more not a paraphrase for over and above?
Well, over and above is not in addition to, it's not something more. It can be something more, it can be something completely different, it can be a combination of both.
Well, if you're right, that over and above is in effect optional, but the judge can just go straight to very compelling circumstances, and it's an unappealable evaluative judgment. Then if you're right about that,
Yep.
then one doesn't need to go into the detail of the upper tribunal judgment.
Absolutely. And just for completeness, 52, my lord, the judge again makes the point.
Same again.
That in addition to, something additional is needed. Yalchin says it's not required. But what the judge is ultimately saying, and I won't take much of your time, is that, well, the findings do not justify the conclusion that there are very compelling circumstances. But that is a matter for the first year tribunal. Absent irrationality, the upper tribunal cannot interfere with this decision.
I think you've probably done ground one.
I am, and I'm not going to spend much time on the second ground. It is, of course, an alternative ground.
Yes.
I won't take more than 15 minutes on the second
All
ground.
right.
Very
Well,
good.
let's break off here, return at 2 o'clock, then you'll briefly deal with ground 2, and then we'll pass the baton on to Mr. Boring.
Good.
Right.